on depending jurisdictional challenges. This subcommittee is in receipt of a letter from Senator Chupisto Gingona III, Chairman of the Senate Committee on Accountability of Public Officers and Investigations, the Blue Ribbon Committee, dated October 7, 2014, referring the following to this subcommittee for proper resolution. 1. Manifestation with motion of Mayor Jejomar Erwin S. Binay Jr., dated October 1, 2014, challenging the jurisdiction of this subcommittee to conduct hearings on PS Resolution number 826. Number 2, letter on behalf of Ms. Ebing Baloloy, dated October 1, 2014, challenging the jurisdiction of this subcommittee to conduct hearings on PS Resolution number 826. Number 3, letter of Attorney Pio Kenneth I. Dasal, Legal Officer of the City of Makati, dated October 2, 2014, on behalf of the department heads of the City of Makati, stating that they are joining the jurisdictional challenge of Mayor Binay. Number 4, letter of Ms. Marjorie De Vera, dated October 2, 2014, stating that she is joining the jurisdictional challenge of Mayor Binay. And number 5, relating to including investigation of malfeasance, misfeasance, and non-feasance in office by officers and employees of the government, its branches, agencies, subdivisions, and instrumentalities. The hearings of this subcommittee were initiated by proposed Senate Resolution number 826, authored by Senator Antonio F. Trillanes IV, which resolves, among others, and I quote, to direct the Committee on Accountability of Public Officials and Investigation committed. So on this ground alone, the jurisdictional challenges may already be properly denied. However, even if a motion for reconsideration, which these letters essentially are, is prohibited by the Senate Rules of Procedure governing inquiries in aid of legislation, this subcommittee will be lenient and will take a second look at the grounds mentioned in the letters of Mayor Binay and on behalf of Ms. Baloloy in the higher interest of justice. The jurisdictional challenge filed by Mayor Binay is based on his allegation that the ongoing hearings of the subcommittee relative to proposed Senate Resolution number 826 are not in aid of legislation, and that the investigation is in fact violative of the rights of the persons appearing therein. This was substantially reproduced in the letter on behalf of Ms. Baloloy and that on behalf of Professor Lopez. As stated above, as stated earlier, Attorney Dasal and Ms. De Vera merely joined the challenge interposed by Mayor Binay. To resolve this sole issue, it is but proper to state what the jurisdiction of the Blue Ribbon Committee extends to. According to Section 21 of Article 6 of the 1987 Constitution, the Senate or any of its respective committees may conduct inquiries in aid of legislation in accordance with its duly published rules of procedure. In accordance with this constitutional provision, the Senate adopted the rules of the Senate and the rules of the Committee on Accountability of Public Officers and Investigation. These rules grant the Blue Ribbon Committee jurisdiction over all legislative matters related to investigate in aid of legislation the alleged 1.601 billion peso overpricing of the 11-story New Makati City Hall parking building, the reported overpricing of the 22-story Makati City Hall building at the average cost of 240,000 pesos per square meter, as well as related anomalies purportedly committed by former and current officials of the City of Makati, and to recommend amendments to the appropriate bidding and procurement laws and policies to ensure the proper use of public funds. Clearly, therefore, the subcommittee has jurisdiction to investigate and conduct hearings on proposed Senate Resolution number 826. Furthermore, in relation to the scope of the power of the Senate to conduct inquiries in aid of legislation, the Supreme Court has stated, and I quote, in Sabio versus Gordon, GR number 174340, dated October 17, 2006. Notably, the 1987 Constitution recognizes the power of investigation not just of Congress but also of any of its committee. This is significant because it constitutes a direct conferral of investigatory power upon the committees, and it means that the mechanisms which the houses can take in order to effectively perform its investigative function are also available to the committees. Verily, the court reinforced the doctrine in Arnault that the operation of government, being a legitimate subject for legislation, is a proper subject for investigation, and that the power of inquiry is coextensive with the power to legislate. As Mayor Binay admitted in his jurisdictional challenge, he already voluntarily appeared before the... It is also the personal opinion of the chairman of the subcommittee that the jurisdictional subcommittee on August 20, 2014. He also admitted that in 3 subsequent hearings on August 25, September 4, and September 11, 2014, he made all department heads of the local government of Makati City attend our hearings. Mayor Binay never raised any challenge to the jurisdiction of the subcommittee at that time or at those times. The jurisdictional challenge should have been brought at the earliest opportunity, as in fact, according to the rules of the Blue Ribbon Committee, a jurisdictional challenge must be raised and resolved before proceeding with the inquiry. Stated in a different way, when Mayor Binay raised his jurisdictional challenge on September 25, 2014, the inquiry had already started and it had already progressed. It was actually Mayor Binay who, during the first hearing of this subcommittee, introduced the concepts of world-class and green that he dictated the agenda for the subsequent hearings of the subcommittee. It is also the personal opinion of the chairman of the subcommittee that the jurisdictional challenge may only be raised by a member of the committee. It cannot be raised by a resource person, and certainly not by any department head who is not even the subject of any investigation of malfeasance, misfeasance, and nonfeasance. The rights of these resource persons are those enumerated in the Bill of Rights and may be invoked only when a question is propounded to them as provided for in Section 19 of the Rules of Procedure governing inquiries in aid of legislation. The witness cannot refuse to testify or answer questions before the objectionable question is even asked. The fact that several ideas have resulted from these hearings for the amendment of existing procurement laws, laws on accountability of officers, and even on the rules of the Commission on Audit, on what are allowable expenses in the construction of public buildings, belie the allegation that the ongoing hearings are not in aid of legislation. Some specific legislative proposals stemming out of this investigation are the following. Number 1, mandatory videotaping of public bidding processes. Number 2, rotation of Commission on Audit personnel to prevent familiarization and camaraderie with the personalities being audited. Number 3, rotation of the members of the Bids and Awards Committee to prevent the same evil being prevented with the COA. Number 4, necessity of a law to define when there is a presumption of overpricing in a government project. Number 5, one project, one ordinance. Simply put, big ticket infrastructure projects must be governed by specific ordinances authorizing their construction, complete with budget allocation as well as plans to be attached to the ordinance. These are just some of the ideas as of this date. Wherefore, the foregoing premises considered, the jurisdictional challenges raised by Mayor Jejomar Erwin S. Binay Jr., Ms. Ebeng Baloloy, Attorney Pio Kenneth Dasal, for himself and on behalf of all the department heads of the City of Makati, Ms. Marjorie De Vera, and Professor Tomas Lopez, are all denied for lack of merit. So ordered. Letter on behalf of Professor Tomas B. Lopez, dated October 1, 2014, challenging the jurisdiction of this subcommittee to conduct hearings on PS Resolution number 826. Although all of these letters were addressed to Senator Teobisto Gingona III, they were referred to the subcommittee for proper resolution. The issues raised in these letters are substantially the same, as in fact the letters of Attorney Dasal and Ms. De Vera merely state that they are joining the jurisdictional challenge of Mayor Binay. They shall therefore be resolved jointly. As the chairman of the Senate Blue Ribbon Committee stated in his referral letter, Section 20 of the Senate Rules of Procedure governing inquiries in aid of legislation gives the subcommittee plenary power, except the power to punish for contempt, and therefore authorizes the subcommittee to resolve issues on jurisdictional challenge. The letters mentioned, therefore, were erroneously filed with and addressed to the chairman of the Blue Ribbon Committee, and should have been instead filed with this subcommittee. Furthermore, Mayor Binay and Ms. Baloloy had already previously filed with this subcommittee on September 25, 2014, a jurisdictional challenge on the same grounds as those contained in the letters mentioned earlier. The earlier jurisdictional challenge had already been denied by the subcommittee, and the letters of Attorney Dasal and Ms. De Vera state that they merely join the jurisdictional challenge of Mayor Binay. The Senate Rules of Procedure governing inquiries in aid of legislation provide in Section 2 that only one challenge on the same ground shall be permitted.